Good morning. This is Judge Betty Rankin-Widgeon. I'm the appointed master in this matter, and we are ready to begin the closing arguments today. Counsel, please place your names on the record.
Good morning. My name is Laura Weingarten. I am one of two disciplinary co-counsels.
Thank
I
you.
am Lynn Helland, and I am the other disciplinary co-counsel.
Thank you.
Good morning, Your Honor. Michael Ashcraft on behalf of Respondent, Judge Tracy Green.
Thank you. And good morning, Judge Green.
Good morning, Your Honor.
All right, thank you. I believe we are ready at this time for the closing arguments, and we will begin with disciplinary counsel. And after you have completed your closing argument and the other side has done their closing argument, you will have the opportunity for a few minutes rebuttal. You may proceed.
Your Honor, with the way this case has proceeded, it's easy to lose focus on what is relevant and what is important. My argument will focus on the relevant and important issues. The evidence shows that Judge Green committed three types of misconduct. First, she concealed that her grandsons were abused. Second, she made false statements about her knowledge that her grandsons were abused. And third, she made false statements about what she had told Child Protective Services about concealing a handprint on Max's face. I'll talk first about the evidence that shows that Judge Green knew full well that her son abused her grandsons, and she concealed that abuse, and she later lied about having concealed it. Between April of 2015 and the day Russell and Max were rescued by CPS in June of 2018, Judge Green was aware of several things that informed her that her grandsons had been abused. Context is very important here. Judge Green knew her son had a history of abusing Russell and Max. She knew that her son's abuse caused Judge Cox to forbid her son to use any corporal punishment on his children. Further, Judge Green was not just any old grandmother confronting abuse. She was a lawyer who practiced juvenile law and held herself out to be a child and family advocate. With that context in mind, paragraph 9 of the complaint alleges that she was aware that on multiple occasions, her son slapped and choked his then wife, Katie. Judge Green denies knowing this. We know she did, though, for several reasons. First, Russell and Max have consistently said, whenever they were asked, that they told her this. She admitted to the commission and during her testimony here that Katie also told her that her son slapped her once, and she admitted that one of her grandsons told her her son choked Katie. When Judge Green testified, she confirmed she was told these things. Judge Green protests that these two incidents mean nothing because they were years apart. Whatever time passed between them does not matter. A mother, a grandmother, and a family law attorney would be attuned to any evidence of abuse like that. Also, the other information Judge Green had about her son's abuse shows that what he did to Katie was part of something ongoing and long-standing. Her denial that she knew her son abused Katie after being told at least twice that he did was not credible. The evidence proves paragraph 9. Paragraph 10 alleges that Judge Green was aware her son was abusing Russell and Max. Again, because context is important, paragraph 10A alleges that she was aware that her son was a very stern disciplinarian. She admitted this to the commission. She admitted in juvenile court that she told Miss Apple her son was a stern disciplinarian. Miss Apple testified that Judge Green told her that her son was a very strong disciplinarian. The evidence establishes paragraph A. During her testimony, Judge Green attempted to minimize her prior statements by claiming that she only meant her son used too many timeouts and took away privileges for the wrong reasons and for an unreasonably long time. But she knew that Miss Apple and the juvenile court lawyers were discussing physical abuse of the boys and not any other type of discipline their father imposed. It would have made no sense for her to call him a stern disciplinarian in this context if she was only referring to lengthy timeouts. Paragraph 10B alleges Judge Green was aware that her son used corporal punishment on his children. Corporal punishment is any physical discipline. Judge Green's answer to the complaint and her testimony here admits that she knew her son used corporal punishment on Russell and Max prior to Judge Cox's order in 2015. But she goes on to claim that she didn't know of any corporal punishment after that date. However, this is what she was aware of that happened after April 30th of 2015. First, her son smacked Max across the face hard enough to leave a handprint that was bad enough and lasted long enough that she felt compelled to cover it with makeup. The smack violated Judge Cox's order prohibiting corporal punishment. Second, Max told her about the other hits to his face that left marks, at least one of which she also covered with makeup. She also likely saw other marks on Max's face because he frequently had marks. Third of all, the boys told her about the spankings multiple times. Fourth, Russell told her that his father used a belt on them, and she testified in juvenile court that she knew her son used a belt to discipline the boys. Fifth, both of the boys informed her of the abuse they suffered and showed her their injuries. Judge Green even told Miss Apple, the juvenile court, and the commission that she knew about the spankings. She now minimizes that, claiming that she was aware of the spankings only, quote, in the past, unquote, by which she meant before Judge Cox forbade corporal punishment. However, when she talked with Miss Apple, she knew Miss Apple was investigating her son's recent abuse of the boys, not events from more than 3 years earlier. When she testified in juvenile court, and she was a lawyer who practiced family law and knew the focus was recent abuse, yet she did not tell Miss Apple or the juvenile court jury that she was aware of spankings only before April of 2015. During its investigation, the commission asked her 6 different questions about her knowledge of the spankings. Judge Green knew very well that the investigation that prompted those questions was concerned about her knowledge of her son's recent abuse of the boys. Each of her 6 answers admitted to knowing about the spankings, quote, in the past, without stating that in the past only meant more than 4 years earlier. In fact, one of the commission's questions explicitly asked her when the children told her their father struck them. This was a written question to her, and she had as much time as she needed to consider her answer. Yet she again said only, quote, in the past, without clarification. Until this hearing, she never stated that she was only aware of the spankings that preceded Judge Cox's order, even though every time she was asked, she had every reason to make it clear if it was true. Similarly, Judge Green testified in juvenile court that she knew her son used a belt on the boys. She knew the court's inquiry was focused on her knowledge of abuse while it was occurring. Yet this family lawyer did not tell the juvenile court jury that she had only learned about the belt during the CPS investigation. It's very telling that the only time Judge Green claims to not have known that her son was spanking or belting the boys is during the years when the boys say they told her these things. For all of these reasons, Judge Green's testimony that she believed the spanking stopped in April of 2015 and did not know about the belt until after the boys were rescued is not credible. The evidence establishes paragraph 10B. Paragraph 10C alleges that Judge Green knew her son hit his children with a belt, and I just covered this. The evidence established paragraph 10C. Paragraph 10D alleges that Russell and Max told Judge Green that they had been spanked by their father on numerous occasions. Judge Green's answer to the complaint does not challenge this allegation, and I've already mentioned the evidence that shows this. The evidence establishes paragraph 10D. Paragraph 10E alleges that Russell and Max told Judge Green about their fear of what would happen to them physically if their father had learned that they had misbehaved at her home. Judge Green denies that her sons expressed any physical concerns to her. But she testified in juvenile court that the boys would express concern that if they had misbehaved, they might get in trouble when they went home. Again, the context is important. In context, the trouble the boys were concerned about had to be physical discipline. She knew as early as Judge Cox's order that corporal punishment was her son's preferred method of discipline. The boys told her that her son spanked them and hit them with a belt and smacked Max across the face on many occasions. On the other hand, the boys never told her they had too many timeouts or that their father took away privileges for unreasonable reasons. To believe Judge Green's claim that she thought the boys were only worried about timeouts, you have to disregard the evidence that the boys told her about the physical abuse, because once she was aware of that, she could not reasonably think that the thing the boys were worried about were timeouts or lost privileges. The evidence establishes the allegations of paragraph 10E. Paragraph 10F alleges that in about 2018, Judge Green heard her son slap Max across the face hard enough to leave a handprint, which Judge Green later concealed with makeup. In addition to other evidence of this, Judge Green has consistently admitted she was aware of a slap and concealed it with a handprint, with a makeup. The evidence establishes paragraph 10F. Paragraph 10G alleges that Judge Green saw other marks on Max's face on other occasions that Max told her had been inflicted by his father. She denies knowing this, but the boys' multiple consistent statements contradict her. Russell testified in this hearing that Max had bruises on his face, and they told their grandmother that their father put marks on their bodies. He also testified that Max told Judge Green about the marks on his body every time Russell did. Max testified in this hearing that he had a lot of marks on his face, which Judge Green sometimes concealed. One time, as she was putting makeup on him, she told him he needed to stop getting slapped. He believes Judge Green probably saw other marks on his face because the marks were there when he saw her. He said he had marks on his face pretty often because his dad smacked him a lot. His testimony was consistent with his prior statements. Judge Green called her husband and her daughter as witnesses. They testified they never saw abusive marks on the boys. Of course, they have a motive to protect Judge Green. They love her and don't want to get her in trouble for ignoring obvious signs of abuse. They also hold some responsibility for allowing the abuse to occur if they saw injuries and did not report them to the authorities. And it would be very embarrassing to them now to admit they saw signs of abuse and didn't do anything about it. Also consider that Mr. Andre Green testified that there is no distinction in his mind between beatings and spankings, and he obviously considered spankings no big deal. He clearly showed that he thought Judge Green was noble for having concealed the handprint. It says a lot about the climate in the Green household that he was not bothered by the fact that his wife was concealing an injury on a child's face that was inflicted by the child's father. Simone was just a child when the abuse was occurring. She could have been easily unaware of what was occurring. But even if she was aware, she may not have realized the seriousness of the abuse, especially because her parents were not concerned. The evidence establishes the allegation of paragraph 10G. Paragraph 10H alleges that Russell showed Judge Green bruises on his body more than once, and he told Judge Green they had been inflicted by his father. Again, Judge Green denies this, and again, her denials are contradicted by Russell's and Max's multiple and consistent statements. The very first time Russell was asked about his grandmother's knowledge in September of 2019, he said he showed her bruises and told her how he got them. During his Zoom interview, he said he showed her marks 4 or 5 times and told her about the marks 5 times. Consistent with his prior statements, Russell testified in this hearing that he showed his bruises to Judge Green. The evidence establishes paragraph 10H. Paragraph 10I alleges that when Russell was about 8, he told Judge Green he was about to be spanked by his father and that Judge Green left the home as the spanking was about to take place. The repeated, consistent statements by both boys show that Judge Green knew the boys were about to be beaten at least once, and Judge Green admits that Russell told her he was about to get a whooping. But she denies the whooping was imminent and claims that before she left, she got her son to agree not to spank Russell. She claims she simply accepted her son's explanation that he was just threatening Russell and would not follow through. Think about that for a minute. She should have been sensitive to the issue of child abuse, given her role as a family court lawyer. And She, by her own admission, never so much as asked the boys whether they were okay. She didn't do anything more to protect them or to make sure her son was complying with Judge Cox's order. She would never have represented one of her juvenile clients so poorly. If she was truly unaware, as she claims, she was only unaware because she deliberately buried her head in the sand when it came to the way her son treated Russell and Max. The evidence establishes paragraph 10I. Paragraph 10J alleges that Judge Green's grandsons told her they had been spanked by their father on other occasions. Judge Green's answer to the complaint did not respond to this allegation, and I've already talked about the evidence that establishes this paragraph. Paragraph 12 alleges that despite the indicia of abusive punishments, Judge Green did not inquire into the nature of her grandson's corporal punishments. She has repeatedly admitted that she never asked about the nature of the spankings. Russell, Max, and Miss Apple all confirmed what she said. The evidence establishes paragraph 12. Paragraph 10K alleges that on multiple occasions, Judge Green saw injuries on Max's face, and on multiple occasions, Max told her that his father had injured him. For the reasons I've already stated, the evidence establishes this allegation. Paragraph 11 alleges that between May of 2015 and June of 2018, Judge Green was aware that her son was under a court order not to use corporal punishment on his children. Judge Green has admitted this. Paragraph 13 alleges that the totality of the evidence shows that Judge Green was aware that her grandsons were abused by her son. For all the reasons I've summarized, the evidence is very clear that Judge Green was well aware of this. In light of all the evidence, something she told Miss Apple is particularly telling. She told Miss Apple after the team meeting 2 days after her grandsons were rescued that she knew her grandsons were being abused, but she didn't know it was, quote, this bad. Think about what that means. If she didn't think the abuse was this bad, she must have been aware that there was abuse, just not as much as there turned out to be. Judge Green's statements to Miss Apple revealed, probably unintentionally, that she knew her son was violating Judge Cox's order and abusing her grandsons. Judge Green denies she was referring to physical abuse when she told Miss Apple she didn't think it was this bad. She claims she was referring to civilized punishments her son imposed, banishing the boys to their rooms or prohibiting them from using their iPads. She says Miss Apple just got it wrong. Now think about her explanation for a minute. Any grandmother, any person who is under the impression that her grandsons are merely getting timeouts and who then learns that in fact they've been physically abused isn't going to say, I didn't think it was this bad. She's going to say, I had no idea there was anything physical going on. It is very telling that that is not what Judge Green told Miss Apple. Judge Green claims that this is not what she told Judge Apple. Rather, she claims Miss Apple had confirmation bias and that Miss Apple interpreted what Judge Green said to support her decision not to place the children with Judge Green. But Judge Green's statements to Miss Apple was pretty simple, and Miss Apple's recording of those simple words was not subject to interpretation. Judge Green denies that she was ever present when corporal punishment took place and says Miss Apple lied about Judge Green telling her that she was there once when her son slapped Max. It's a pretty strong allegation to say that Miss Apple, a public servant, lied about what Judge Green said. She has no reason to lie about Judge Green's statements. She and Judge Green did not even know each other before CPS rescued the boys. The totality of the evidence clearly shows that Judge Green was aware that her grandsons were being abused by her son. Paragraph 14 alleges that on multiple occasions, Judge Green put makeup on Max's injuries for the purpose of attempting to conceal them. Max has consistently and convincingly said this every time he was interviewed about his grandmother's conduct. During Max's testimony at this hearing, he says Judge Green put makeup on the handprint in her upstairs bedroom after his father drove him to her house at nighttime. The makeup was in a black palette and respondent was talking to Katie while she put the makeup on him. This happened more than once, maybe 2 or 3 times. During Russell's first interview, he said Judge Green put makeup on him before he was 9 years old. Even Judge Green admits to putting makeup on Max, though she claims she did so only once and only because Russell was teasing Max about getting slapped. Judge Green's excuse is false. In the first place, both boys testified that they did not tease each other about getting hit by their father or the fact that they had marks on their faces. Also, if Judge Green's explanations were true, she would have mentioned it way earlier than she did. As an experienced lawyer and eventually a judge whose specialty was juvenile cases, she was well aware that evidence a parent caused physical harm to a child is a very big deal, and that concealing evidence that a parent caused physical harm to a child is also a very big deal. Therefore, if she had an innocent reason for putting makeup on Max's mark, she had every reason to tell CPS that when asked about her knowledge of abuse, and to tell the juvenile court jury that when asked about concealing abuse, and to tell Mr. Alrick when he interviewed her about her concealing abuse. But she never did that. She didn't come up with that explanation until the Judicial Tenure Commission began to ask about it. Paragraph 15 alleges that she knowingly concealed evidence that Russell and Max were abused. And if she did this, she violated a host of rules and statutes. The evidence has established that she knowingly concealed evidence of abuse. There is no real question that if she did so, she violated the listed rules and statutes. Count 2 alleges that Judge Green made several false statements about her knowledge that her son abused Russell and Max, and about her actions with respect to that abuse. Paragraphs 19 to 27 allege that Judge Green falsely denied knowing about the abuse of her grandchildren. The evidence I've already summarized shows that, in fact, Judge Green was well aware of every one of the things that are alleged in these paragraphs that she denied knowing. I won't restate that evidence here. Much of the evidence that shows her knowledge came from Max's and Russell's testimony. In fact, counts 1 and 2 are largely a credibility contest between Russell and Max on the one side and Judge Green on the other. It's undoubtedly for that reason that Mr. Ashcraft made every effort to cast doubt on the boys' testimony. But his shots have missed the mark. The boys are more credible than Judge Green is. I'm going to show why they are, and also talk about some things in this record that do not matter to their credibility, even though Mr. Ashcraft has put a lot of emphasis on them. One thing that does not affect the boys' credibility is that they were interviewed multiple times. As Nancy Deal testified, it's important to know why there were multiple interviews. The only reason Max and Russell were interviewed so often is that they first had to explain what happened to them. Then they had to testify in juvenile court. Then they had to testify at their father's criminal trial. Then they were asked for the first time about Judge Green's actions. Then they had to get prepared to testify in this hearing. If you doubt this, please read through each transcript and watch each video of the interviews. You'll see that none of the interviews were leading or suggestive. It's a bit misleading to talk about the number of times the boys were interviewed in total without recognizing that only a few of those interviews were about the facts that matter to this case. It doesn't matter how often the boys were interviewed about the abuse, because this case isn't about the abuse. It's about Judge Green's knowledge of the abuse. Russell was only interviewed once about her knowledge, and again when I prepared him to testify here. Max was only interviewed about it once, and then he discussed it again when I prepared him to testify here. As you know, several of Max's interviews were largely collateral to the charges in the complaint. They were an effort to get to the truth about the Dear John letter he sent. Nancy Deal testified that the forensic interview protocol protects perpetrators. This is a classic example. Had we not investigated thoroughly, Max's lie might not have been discovered, to the detriment of Judge Green. She benefited from the multiple interviews of Max about the Dear John letter, and from me following the protocol to find out it was not her who instructed him to send that letter, although he first said it was. Another thing that does not affect the boys' credibility is whether they said anything about their grandmother during the early Kids Talk interviews. Those interviews had nothing to do with Judge Green. They were focused on the way the boys were abused by their father and Katie. If the interviewer didn't ask about Judge Green, the boys had no reason to talk about her. Mr. Ashcraft also attacked the boys for minor changes in their memories. This too says nothing bad about their honesty and credibility. No one would expect Russell and Max to remember what they were asked in each of their interviews or the details of which they told each interviewer. As you know, the investigations took place over the course of 3 years, from June 20 of 18 through July of 2021. That's more than a quarter of the boys' lives. It's a very long time for children to remember specific details. Also, it's hard for anyone to keep track of the specifics when something happens in a similar way multiple times. Also, as Max said more than once, it really did not register as a big deal with him that his grandmother covered bruises with makeup. Unlike the actual abuse, the boys had no strong reason to keep track of their grandmother's reasons and actions. If you doubt their inconsistency, again, please compare their interviews over time. They are all substantive evidence in this hearing. If you do that, you'll find that what they've said about relevant and material things is pretty consistent. Our proposed findings of fact will have a summary of what each of the boys said with citations. Mr. Ashcraft told you in his opening statement and has attempted to solicit evidence that Corey Bressler is the driving force behind the boys' allegations about their grandmother. But it is clear she had nothing to do with what the boys have said about the abuse. The relevant evidence concerning Ms. Bressler is that in the first part of 2018, she sent the boys emails that encouraged them to report the abuse to Child Protective Services. She did not mention Judge Green's name or give any directive to lie about Judge Green. Mr. Ashcraft makes this sound sinister, but think about how odd that claim is. Put yourself in Ms. Bressler's shoes. You're a mother who's hearing that her sons are being abused, but who has a very restricted ability to communicate with them. You would naturally tell your children to report the abuse. What you would not do is try to use your boy's crisis to attack someone else who had nothing to do with the actual abuse. Mr. Ashcraft's claim makes no sense, and there is no evidence to support it. Even after the boys were living with Ms. Bressler, there's no evidence that she told them what to say. This is critical. When I interviewed the boys, I deliberately did not tell Ms. Bressler what I wanted to talk to the boys about, and they had no idea. There was just no room for any coaching under these circumstances. I asked the boys over and over whether anyone told them what to say or not to say about Judge Green, and they said no every time. They said over and over that the only thing their mother told them to do is to tell the truth. There's absolutely no evidence to the contrary. Further, if Ms. Bressler had wanted to coach the boys, she would have instructed them to make false statements about Judge Green to CPS because she was well aware that CPS was investigating. But the boys didn't say anything about Judge Green to CPS. The evidence includes YouTube videos and a radio interview of Ms. Bressler, in which she is irate about Judge Green protecting and supporting her son rather than her grandsons. In one of the videos, she tells the viewers that Judge Green should not be elected judge because she should not be making decisions on behalf of Wayne County families when she did not protect her own grandsons. While Ms. Bressler did not behave in a dignified manner in creating these videos, it is clear that her words were heartfelt. If, as the evidence shows, Ms. Bressler's sentiment, if, as the evidence shows, Judge Green was aware of the abuse and did nothing to stop it, Ms. Bressler's sentiment is not only understandable, it is appropriate. Any mother would be furious at her ex-mother-in-law under these circumstances. But Ms. Bressler's dislike of Judge Green and her statements that she should not be elected are a far cry from telling her children to lie about Judge Green's conduct. Judge Green testified that she has had no communication with Ms. Bressler since the divorce in 2015. While there may be bad blood between Judge Green and Ms. Bressler has nothing to do with this case, and all the unfounded innuendo in the world cannot change that. Counts 1 and 2 require Your Honor to make credibility assessments. I ask you to consider some things about Russell, Max, and Judge Green when determining who is telling the truth. Do they have a motive to lie? Is there corroboration of their testimony? Are each of their statements over time consistent with prior statements they have made as to the relevant and material issues in this case? I'm going to discuss motive to lie. Max loves his grandmother. Throughout this hearing, it was clear that he still loves his grandmother. He wanted to communicate with her during these proceedings, and he initiated communications. He admitted he does not like telling people about the things she knew and what she did, and he wished he didn't have to testify. Those are not the feelings of someone who is testifying falsely because he has been coached. At one point, he answered questions that he thought were helpful to his grandmother's case and informed Mr. Ashcraft, quote, "I was trying to help your client." As recently as May 15th, he texted Judge Green saying, "I love you so much, though. I love you, Grammy. I know you can't respond to my text, but I do. I hope they just dismiss this case just like they do every other one. I can't wait to see you again." As you know, Max did lie in May about his grandmother to an interviewer at Kids Talk and to me. Mr. Ashcraft has focused a lot of attention on this lie. The lie was about who told him to write a letter to his father's friend, John. Max clearly shouldn't have lied about that, but nothing about that lie suggests that he has made any false statements about Judge Green here. As Nancy Deal testified, before deciding whether a known lie means a child cannot be believed about anything, you have to look at why he lied and what he lied about. Some children can explain the reason, and it makes perfect sense given the situation. Other times it means they're not being truthful. Max explained why he lied, and from his perspective, it did make sense. He lied because he understood his dad wasn't allowed to talk to him while on bond, and he didn't want to be responsible for sending his dad back to jail. That is a lie that makes sense, given the situation he was in. To his credit, Max came clean about the lie, and this is critical. He came clean about it to Judge Green right after he told it. He was obviously not comfortable with the lie. If he were telling other lies about her, he would have told her about those as well. He has not done so. That's because his statements about her that matter to this case are all true. During one of his several meltdowns Max had during this hearing, he said, quote, "So I have no intention of lying. What do I get out of that?" Unquote. That is not a rhetorical question. Think about what Max would get for lying against Judge Green. The answer is that he does not get a thing. Now, Russell did not have as warm a feeling about his grandmother as Max did. In his interview with me, he remembered nice things she did for him, but he said he didn't like her because she was mean and yelled at him. He even said he hopes he never sees her again. The question for you is, Your Honor, whether because Russell thought his grandmother was mean, he decided to make things up about her. That is a huge leap. It's especially a huge leap because Russell was only 8 years old when he was rescued and 9 when I interviewed him. At those ages, he was not sophisticated enough to make up a big lie about Judge Green and tell it consistently over a period of years. Not liking someone is a far cry from making up a lie about them and retelling that lie over and over again. For the boys to have lied about Judge Green, each would have had to make up the same story. Think about that for a minute. When I first interviewed the boys, neither of them knew why I wanted to talk to them. Yet what they had to say about Judge Green's knowledge was completely consistent with each other. How could they have done that if they were not telling me the truth of their truthful memories? You heard me testify my experience as a forensic interviewer. I was trained in the protocol in the late 1990s and have interviewed hundreds, if not thousands, of children using the protocol. If you doubt the boys' credibility at all, I encourage you to watch my interviews of them. You can determine whether I followed the protocol. I did the hypothesis testing required by the protocol. I asked questions designed to elicit whether the boys had a motive to lie or to determine whether anyone coached them to lie about their grandmother. I did hypothesis testing to check whether Judge Green had an innocent reason for putting makeup on the boys' faces, say because it was Halloween, because they were in a school play. The boys denied those hypotheses. Ms. Deal testified that if the interviewer is well trained in the protocol, very experienced at interviewing kids, and follows the protocol, she is less concerned about there being bias. If the interviewer does hypothesis testing, which is part of the protocol, allows the child to say what happened, and allows a child-centered interview to occur, that also allays her fears about bias. Video recording the interview is also important because it proves whether the interview was done correctly. My interviews of the boys satisfy every one of her criteria. The first time I interviewed Max, I asked him how he felt about his grandmother to see whether he had a motive to lie. He told me he got along with his grandmother and she did nice things for him. I also asked him if there were some things that were not so nice. And all he reported was that his dad abused him and his grandmother put makeup on his face, that his grandmother saw his dad hitting him in the face and did nothing about it, and that he and Russell told their grandmother they were about to get beat by their dad, but she did nothing about it and left the home. Max said these things without the least hint of suggestibility that I was looking for answers of that sort. In fact, they are the same things that made him freeze in fear when Officer Adams and Miss Apple first spoke with him about being placed at his grandmother's house on the day they were rescued from their father's home. I also asked Russell during his first interview about how he felt about Judge Green. He also talked about nice things she did for him. Russell also reported mean things she did to them, including that one time she put makeup on his bruises. Again, there was absolutely no suggestibility in this question or Russell's answer. Your Honor should consider Judge Green's own motives to lie as well. She has multiple reasons. First, she obviously doesn't want you to find that she committed misconduct. Second, she doesn't want the legal community, the media, or her electorate to know that she sanctioned her son abusing her grandsons and did not intervene other than to conceal the abuse so others wouldn't see it. Third, she clearly continues to support her son, and by pretending the boys are lying about the abuse and whether she was aware of it, she can better support her son. Judge Green has said she had a great relationship with Russell as well as Max. So why would both boys make up something so damaging to her when she was so good to them and they had such a great relationship? Next, consider whether there is corroboration of what the boys said, and there is. Max's first statement about Judge Green that he made to Miss Apple and Police Officer Adams is the single most important fact that has come out in this hearing. He testified he, quote, had no clue that CPS or the police would be coming to his home during the afternoon on June 24th, 2018, after the police had already come and gone that morning. The boys were separated from their father, and as a result, for the first time, felt comfortable revealing the horror of what was occurring in their home. After showing Miss Apple and Officer Adams their injuries, Miss Apple told them that Judge Green volunteered to take them in. Max's body froze, and he showed signs of emotional distress. He immediately said he did not want to go with his grandmother because, as Officer Adams testified, quote, she knew about what the dad was doing to them, about the abuse, and she would allow the dad to get back and come and see them, unquote. This was a spontaneous statement made without any chance of any communication with his mother. It shows that the boy's statements and the testimony about respondents' knowledge of abuse is truthful. What other corroboration is there? The boys' testimony corroborates each other in that they have always testified and spoken similarly about how Judge Green knew about the abuse and the fact that she didn't do anything about it. They couldn't do that if they were making it up. In addition, each of the boys say Judge Green put makeup on their faces. Russell's memory was weak on that point, so we deleted that allegation from the amended complaint. But his earlier statements corroborate Max's, that Judge Green used makeup to cover their injuries. There's more corroboration. We know there were severe injuries on the boys on June 24th of 2018. Miss Apple said that on a scale of 1 to 10, the injuries were an 11. Injuries like that don't usually happen out of the blue during first-time abuse. Furthermore, a juvenile court judge the juvenile court jury terminated their father's parental rights based in part on the boy's testimony. And a criminal court judge convicted Gary Davis Head Sr. of 2 counts of child abuse in the 2nd degree and sentenced him to prison time based in part on the boy's testimony. Most importantly, much of the corroborating evidence came from Judge Green's statements to Miss Apple, her answers to the commission, and her testimony, although she always minimizes her action and knowledge. Max said they told her what was going on in their lives, and Judge Green admits the boys confided in her. She admits to having been told that her son choked and slapped Katie. She admits to knowing that her son was a very strong or stern disciplinarian. She implicitly admitted to Miss Apple that she knew the boys had been abused when she said she didn't think it was this bad. She admitted to knowing her son hit Max across the face, leaving a handprint. She admitted that despite all the red flags of abuse, she does not recall asking any question about how the boys were being disciplined. The boys testified she did nothing to protect them. She admitted to concealing a handprint on Max's face with makeup. Max testified to this as well as other occasions during which his grandmother put makeup on him. In short, Judge Green corroborates the heart of what the boys have said, even while doing a lot of minimizing. For the reasons I've mentioned, a plethora of evidence contradicts Judge Green's denials that she knew about the abuse and her attempted innocuous explanation for putting makeup on a handprint. You also should consider whether the boys' statements over time are consistent with prior statements they have made as to the relevant and material issues in the case. Our proposed findings of fact will cite all the boys' prior statements, and in the interest of time, I won't go through them now. Finally, please consider whether Judge Green's statements over time are consistent with what she has previously said. One of her prior statements about count 1 contradicts her answer to the complaint. In 2019, she wrote to the commission that, quote, what looked like a handprint went away shortly after it was brought to my attention, unquote. But she wrote that she was not successful in covering up the mark. Those two answers cannot be reconciled, and the facts show that the handprint did not disappear quickly. Judge Green first saw it at the boys' home. She didn't try to conceal it until she had taken the boys to her own home. If the handprint went away quickly, it would have been gone or fading to insignificance by the time they got to her home, and there would have been no need to try to conceal it with makeup. In order for her to argue that the handprint was light or fading, Judge Green needed to shorten the time period between when she knew her son smacked Max and when she put makeup on it. She is the only witness who says she first saw the handprint when the children were at her home. Both of the boys testified they were in their father's home when she heard the slap and saw the slap mark. And that makes Miss Apple's testimony on this point hugely important. Miss Apple testified that Judge Green told her that the incidents occurred at her son's house, that she heard the slap and then saw the mark there. Judge Green testified at this hearing that Miss Apple lied during her testimony about Judge Green telling her this. So this amounts to a credibility contest between Russell, Max, and Miss Apple on the one side and Judge Green on the other. The boys have no reason to lie about where the slap took place and whether their grandmother was present when it occurred. Miss Apple, who was just doing her job, had no reason to lie about Judge Green's statements to her. Judge Green is not credible on this issue. Her statements about whether she put makeup on Max have changed over time too. She testified in juvenile court on March 13, 2019, and she denies ever having seen bruises on Max's face, but admits to seeing a handprint. The question and answer went as follows. Questions. Have you ever used makeup to cover up Gary and Russell's bruises, specifically on Gary's face? Answer. Again, I have never seen any bruises. Question. That wasn't my question. Answer. So the answer is no. Question. If Gary testified to that yesterday, that would be a lie, correct? Answer. Yes, it would. Had Judge Green concealed his handprint with makeup to prevent teasing, it would have been the most logical thing in the world for her to mention it when asked these questions. But she did not do that. And think about this. Judge Green did not even hesitate to call her grandson a liar for having claimed that she covered a bruise with makeup. Had she concealed the handprint for what she believed to be a legitimate reason, she never would have accused her grandson of lying under these circumstances. She would have said something like, oh, he's probably just thinking about the time I covered a handprint with makeup. She didn't say that because at the time she was hiding the fact that she used makeup to hide abuse. Next, she's interviewed by Fox 2 reporter M.L. Elrick a few months later, and it's even more clear she was hiding her use of makeup to conceal abuse. She said, quote, I didn't put makeup on any bruises to conceal any abuse. That is utterly preposterous. It just didn't happen. Now, it's certainly not preposterous to say she put makeup on a bruise to conceal abuse if what she did is put makeup on a handprint that was lingering. But during her interview with Mr. Elrick, she didn't tell him she put makeup on Gary Jr. to cover the lingering handprint to prevent teasing. Respondent claims Mr. Elrick was biased. The first response to that is it simply doesn't matter because Judge Green's own words are captured on the video. It was not any bias by Mr. Elrick that caused her to say falsely that it was preposterous that she would conceal abuse with makeup. The second answer to her claim of bias is that throughout her dealings with Mr. Elrick, Judge Green was represented by a media consultant she retained. They had a 3-hour meeting with Mr. Elrick. She testified she never asked Mr. Elrick to do a correction or retraction of the story that aired. And in addition, she never asked any other media outlet to do a report on the story to correct Mr. Elrick's report. Her story about the makeup continues to change. The first time she mentioned to any official that she had concealed an injury with makeup was in her answers to the commission's questions in November of 2019, when she said she concealed the handprint to prevent Russell from teasing Max. She had never mentioned that before to CPS or in the juvenile court or to Mr. Elrick. Then her story changed some more. In her answer to the complaint, for the first time, she claimed she told CPS she put makeup on Gary Jr.'s face. But she never previously said she told this to CPS, not in her answers to the commission's questions and not in her answers to the 28-day letter. Then, during her testimony on September 17th of 2021, she claimed that she's uncertain she told CPS she put makeup on Gary Jr.'s face. And I'll talk about that more when I talk about count 3. That's the progression of Judge Green's stories about her use of makeup on Max. The truth stays the same. Lies change. Judge Green's answer to the complaint claimed she was being truthful when she testified in juvenile court that she did not conceal any bruises because she distinguishes between bruises and a handprint. She claims they are two different things in her mind. There are several reasons that doesn't make sense. Most importantly, Mr. Ashcraft and Judge Green have worked very, very hard to make this handprint seem insignificant, but it clearly was significant. The handprint did not go away. It stayed long enough that Judge Green took Max to her house, and it was still bad enough that she thought she should conceal it with makeup. The common understanding of the word bruise would certainly apply to a mark like that. Moreover, Judge Green had to know that concealing a lingering handprint of that intensity was relevant to the question she was asked about concealing bruises and was tantamount to concealing abuse. But she did not mention that and instead denied concealing anything and even accused Max of lying. She misrepresented by omission and in doing so misled the juvenile court jury. The evidence shows that her answer was false. What this amounts to is a credibility contest between Judge Green and her grandsons. The boys have no reason to lie about whether they teased each other about getting slapped by their father or about their father leaving marks on them. Judge Green has a reason to lie about this. She has to explain why she concealed evidence that her son abused her grandson. She can't admit that she did it to protect her son, so she made up an innocent reason, but her innocent reason is false. When considering credibility, please consider this. When Max called Judge Green in the spring of 2021, She told him she put makeup on him to prevent Russell from teasing him. It was bad enough that Judge Green was communicating with Max, who she knew was going to be a key witness in this hearing. The facts of this case had nothing to do with Max's reasoning for calling her. Certainly, Max never asked, "Granny, why did you put makeup on me anyhow?" Rather, this only came up because Judge Green deliberately inserted her claim into the conversation, and she had no reason to do that other than to try to plant the false seed in Max's mind. In other words, she tried to do exactly the coaching that she accuses Miss Bressler of doing. But unlike Miss Bressler's alleged coaching, there is evidence of Judge Green's coaching. Judge Green's attempt to get Max to buy into her excuse for putting makeup on him was completely inappropriate. She denies doing this, but why and how would Max make this up? As you know, Judge Green knew Max had lied to Kids Talk about whether it was she who told him to write the Dear John letter. She admitted during her testimony she never told Max to correct his lie and didn't tell you or us that Max lied, even though she knew we were investigating the situation and we had put it on your radar. Judge Green is not a credible person, and you should not believe much of what she has said. The evidence establishes that she made false statements about her knowledge of child abuse. There is no real question that if she did so, she violated the court rules, canons, and rules of professional conduct that are listed in paragraph 34 of the complaint. Unlike counts 1 and 2, count 3 does not depend in the least on Russell's or Max's credibility. In the answer to complaint, Judge Green swore under oath that she had told Child Protective Services that she used makeup to cover a handprint on Max's case. This was the first time Judge Green made the statement. She believed this so strongly that she said it 5 separate times, and each time she was unequivocal. But the evidence shows that she never gave the information to Child Protective Services. Ms. Apple was equally unequivocal that Judge Green never told her she covered up any marks with makeup. She said it would have been a big deal had Judge Green done that, and Ms. Apple would clearly remember it. Ms. Apple's reports, made contemporaneously with her interviews of Judge Green, corroborate her memory. The reports do not include any such statement from Judge Green, and as Ms. Apple said, she would have included such statement in her report. Even Judge Green has recently backed off whether she told Ms. Apple she had used makeup on a handprint of some kind. Technically, that's a smart move on her part. Had she stuck to her original claim, she was not going to win a credibility contest against Ms. Apple and Ms. Apple's reports. The evidence is clear. Judge Green did not tell Ms. Apple that she used makeup on a handprint or on anything else. The only question is whether Judge Green knew that her 5 answers to the complaint were false when she made them. The only way to answer that question is to look at the circumstances. The first important thing to note is that Judge Green's answers to the complaint were self-serving. She was accused of using makeup to conceal evidence of abuse, and she was accused of falsely denying that when she testified in juvenile court and when she was interviewed by Mr. Elric. If she had previously provided this information to Ms. Apple, her doing that would be significant evidence that she wasn't trying to conceal anything in her later statements. That was her incentive for making this claim in her answer to the complaint, to rebut charges that she was lying on other occasions. The next important thing to note about this statement is that Judge Green believed that the strict confidentiality rules that governed CPS records would protect her lie from being exposed. But for a unique exception in the child protection law that applied to this case, disciplinary counsel would not have been successful in obtaining the CPS records or the live testimony of the CPS employees. The next important thing to note that Judge Green has strenuously resisted disciplinary counsel's efforts to obtain and introduce evidence to contradict what Judge Green claimed she told Ms. Apple. You would think that if she believed her statements were truthful, she would embrace the opportunity to have CPS confirm their accuracy. She has done the opposite. The next important thing to note is that Judge Green did not so much as hint that perhaps she was mistaken until it became crystal clear that Ms. Apple would testify, and her testimony would contradict Judge Green's claim that she told Ms. Apple she concealed a mark with makeup. Until that point, Judge Green simply tried to undercut the reliability of the CPS reports that contradicted her. The next important thing to note is that Judge Green's claim that she told CPS she had concealed a mark of abuse by using makeup is not the sort of thing she would have likely to have remembered incorrectly. Again, Judge Green was a lawyer who practiced juvenile law when CPS investigated whether her grandsons were abused. She would have been well aware that concealing the abuse that was under investigation was a really big deal. She would have known to report having done that to CPS, if for no other reason than that her doing so helps her show how severe the handprint was. As a lawyer, she would have known it was a big deal to tell CPS about concealing the mark had she done so. She could not reasonably have forgotten whether or not she did that at the time she was swearing that her answers in the complaint were true. The last thing to note about Judge Green's statements in her answer to the complaint were that they were just not casual statements. These statements were made in response to a public charge that Judge Green lied about concealing evidence that her grandchildren were abused. She made these statements under oath. She would have worked very hard to ensure that every one of her answers to the complaint was as accurate as it could be. The evidence shows that Judge Green has tailored her testimony and her amended answer to explain away evidence that she never thought she would have to face. It is clear that Judge Green's repeated statements in her answer to the complaint that she told CPS she put makeup on a handprint were false, and she knew they were false when she made them. Paragraph 41 alleges that Judge Green's false and misleading statements violated court rules and the Michigan Code of Judicial Conduct. If you agree that the evidence shows that she knowingly made these statements, there can be no disagreement that her false statements violated the named rules. One might wonder why Judge Green would put herself in the position she's in, given that she has devoted much of her career to child protection and advocacy. The answer is clear. She was more invested in protecting her son and helping him avoid responsibility for his actions than in protecting her grandchildren. Then, instead of admitting she was protecting her son, she tried to make her grandchildren out to be liars. In addition, in 2018, she was running for judge. She ran on the platform of being an experienced family and child advocate, a former foster care worker. She didn't want the media or the electorate to know that she knew her son was an abusive father and that she knew it and did nothing to protect her grandsons. That would have been embarrassing to her and would likely have cost her votes. She couldn't come clean and admit she knew about the abuse or that she covered the injuries with makeup. So instead, she has lied to promote her own career goals. The evidence has established by at least a preponderance of the evidence the disciplinary counsel have proven the allegations in counts 1, 2, and 3 of the amended complaint. Thank you, Your Honor.
Thank you. At this time, Mr. Ashcraft, before we have your closing argument, we're going to take a 5-minute break and then we'll come back and continue.
Understood. Thank you, Judge.
Thank you. You may place your microphones and your videos off at this time. I believe we are ready to continue. Mr. Ashcraft, please.
Thank you, Judge. As Your Honor noted on September 15th, the timeline and development of this matter became increasingly more complex over the course of time. You have presided over 11 days of proofs and multiple additional days of arguments on evidence issues. Judge Green and I appreciate both your attentiveness and handling of this case. Let me begin with these principles to which Judge Green has committed her entire professional life, including that brief part of her professional life in which she has been a judge. First, it's not a crime to discipline a child. Second, all children deserve to be fully protected against abuse. Nothing I will say in defense of Judge Green in the face of these charges, and nothing either Judge Green or I have said, or any position we have taken in this case, should be interpreted to compromise our sincere, steadfast commitment to these principles. Your decision in favor of Judge Green will in no way compromise them either. Please note that this is not a more common or typical judicial tenure commission matter in which a judge is charged with doing something wrong in the deliberative processes of her courtroom. Nor is it a situation in which a judge is accused of misuse of her office outside the courtroom for some personal gain or professional advancement. This is instead a judicial tenure matter in which a lawyer who has recognized and represented the rights, welfare, and best interests of children, parents, and families for her entire occupational and professional careers is accused of not telling the truth about what she knew about her own family, about what she knew about her own grandsons, who she has always loved and still does. Judge Widgeon, you already know, and I will, during this closing, review the highlights of our view of the evidence before you. The greatest part of that evidence is simply that the only actual eyewitness to the most material aspects of this case is Judge Green herself. Her entirely exculpatory testimony is the only testimony which has been consistent and clear throughout. Please allow me for a moment to think with you about what happens to all judges if these charges stand. If these charges stand, then judges who are parents will not be able to be parents in full. If these charges stand, then judges who are grandparents will not be able to be grandparents in full. I respectfully suggest that our most treasured civil rights, one of which is the right to raise our children and to nurture our grandchildren. Those who take the oath have the privilege and bear the responsibility to preside over a court of law should not lose those treasured civil rights. Judges remain parents and grandparents, of course, but if these charges are sustained, Judge Green's case will admonish all judges who enjoy full family lives that they may not function as parents or grandparents. Instead, because of their positions as judges, they do not hold the same right to address problems within the family by consoling a grandson, which is what Judge Green did here, and chastising a son, which Judge Green did here. But that is somehow not enough because they are judges. That is not the law. Those are not the rules which do or ought to govern judicial conduct. The facts of this case do not support a finding of judicial misconduct at any level. At the beginning of this proceeding, I submitted to you my belief of what the evidence would show in this case. I noted that the charges were based upon inaccurate statements made by Judge Green's grandsons, Jerry Jr. and Russell, boys who are now 13 and 11 years of age, respectively. I highlighted that the boys had lived in less than stable family environments and that in 2015, when they were 7 and 5, their mother, Corey Bressler, lost custody of them. She blamed Judge Green for orchestrating her loss of custody in 2015 and mounted a campaign to destroy the character and reputation of Judge Green. Those videos from her YouTube channel are in evidence. Your Honor will have the opportunity to review them in their entirety, and I would respectfully encourage you to do so. Corey Bressler then abandoned her son for 3 years. The boys lived with their father, stepmother, and step-siblings until June of 2018, when they were removed from their home by Child Protective Services due to reports of physical abuse and were placed back with their mother. I pointed out that not until that time did the boys ever allege that their grandmother, Judge Green, was aware of the corporal punishment they received at the hand of their father. Not until then did the boys claim that Judge Green saw signs of abuse and did nothing about it. You've now heard all of the evidence. The totality of that evidence does not support the charges against Judge Green. The Michigan court rules establish the rules applicable to the formal hearing process on a Judicial Tenure Commission complaint. One of those rules, MCR 9.233, requires that disciplinary counsel present evidence in support of the charges set forth in the complaint. Critically, the rule goes on to say that, quote, at all times, close quote, disciplinary counsel shall have the burden of proving each of the allegations by a preponderance of the evidence. Each element of each charge must be proved. Disciplinary counsel has systemically failed to do so in a number of respects. There are 3 counts or charges against Judge Green in this case. Count 1, covering up evidence of child abuse. Count 2, false statements about knowledge of child abuse. And count 3, knowingly false statements to the commission. The first 2, by definition, require proof of 2 foundational elements before you can even consider the charges: the existence of child abuse and actual knowledge of that child abuse. Neither is found in this record. When charges are made, they must be specific. They cannot be general. How else can someone defend against them if they are not specific? The details of the who, what, when, why, how, and where are required for specificity. As to this first foundational element, child abuse, corporal discipline of a child is not prohibited by the civil or criminal laws of the state of Michigan. Nancy Deal, the only expert witness to testify in this case, confirmed that is the law. Child abuse, however, most certainly is prohibited. Unfortunately, Michigan does not specifically define what is and what is not appropriate discipline within the bounds of the law. Michigan has both a civil and criminal statute defining child abuse. Civilly, child abuse is defined as harm or threatened harm to a child's health or welfare that occurs through non-accidental physical or mental injury. That's MCL 722.622. The criminal definition of child abuse is more expansive than the civil definition and includes levels of degree. That statute defines child abuse in a matter of first, second, third, and fourth degrees. In terms of understanding how child abuse is addressed in our court systems, the Michigan criminal jury instructions are helpful. Michigan criminal jury instruction 17.24, titled Parental Discipline, states, number 1, it is not a crime to discipline a child. A parent may use force to discipline a child, but this does not mean that any amount of force may be used. The law permits only such force as is reasonable. Clear from that first section of the instruction is that force, specifically corporal punishment, may be used to discipline a child, but only if it is reasonable. The second section of the instruction addresses the required burden of proof. That is significant in this case. That section says, quote, the defendant is not required to prove that the acts alleged here were reasonable. The prosecutor must prove beyond a reasonable doubt that the force used was not reasonable as discipline. It specifically makes reference to the acts alleged here. Disciplinary counsel do not get to define what child abuse is. Disciplinary counsel is not entitled to simply state that it had occurred. There must have been a finding that it had, in fact, occurred on specific occasions. No evidence of unreasonable force or child abuse is found in this record. In fact, the only instance of child abuse that has been proved in this record occurred on June 24 of 2018. This is one of the systemic shortcomings of disciplinary counsel's proofs. As noted in the jury instruction, there are no specific, quote, acts, close quote, alleged here. No establishment of a date and time that alleged child abuse occurred, let alone that Judge Green observed it on a specific date and time and did nothing about it. We have heard vague, ambiguous, and contradictory testimony of there having been, quote, marks, close quote, on the bodies of Judge Green's grandsons. We have heard vague, ambiguous, and contradictory testimony from her grandsons to the effect that Judge Green, quote, saw, close quote, those, quote, marks, close quote. But no further details have been provided. Nothing else is found in the record about these allegations. No actual evidence has been presented in support. Evidence in the form of an admission by Judge Green does exist in this case, but that only as to a single incident in which she saw a red mark on the face of her grandson, Gary Jr. She admitted that she saw a red handprint on his cheek, not a bruise, but a red handprint. Recall that Gary Jr. testified on day 3 of this formal hearing that it was a, quote, pinkish handprint, close quote. Judge Green saw a handprint once and only once, and she never saw any other marks at any time. There is no evidence to the contrary. She testified that she never saw any mark of any sort on the body of Russell. But a red handprint left on the cheek of someone slapped is not child abuse. Disciplinary counsel has presented no evidence to support that a slap and resulting red handprint amounts to child abuse. There is no expert testimony in support. Disciplinary counsel had the opportunity to call an expert in this case, but they did not do so. In fact, recall that the only expert witness who did testify in this case, whom disciplinary counsel acknowledged as an expert in the areas of the child forensic interview protocol and Michigan child protection law, was Nancy Deal, and she was called by Judge Green. Nancy Deal is a 43-year State Bar of Michigan member, a Wayne County prosecutor for nearly 30 years, and notably, the mentor and former boss of disciplinary counsel, Ms. Weingarten. Nancy Deal testified that she had never seen a case in which a slap to the face of a child that left a red mark was found to be child abuse. Nancy Deal also noted that she had never seen a case in which such a thing was ever charged as abuse. In fact, Mr. Gary Davis Head, the boy's father, was never charged with the child abuse over the handprint incident, nor was this incident alleged in CPS's petition filed in the child welfare proceedings in juvenile court. Disciplinary counsel has attempted to bootstrap the demonstration of this first child abuse element through the testimony of Gary Jr. and Russell. They did testify that Judge Green, quote, saw marks, close quote, and, quote, knew, close quote, they were being beaten by their father. These boys were only 13 and 11 when they testified in this case. They were 10 and 7, and even younger when they claimed that Judge Green saw marks and knew they were being abused. Their testimony was inconsistent across the interviews, with each other's statements and with their own statements that began in 2018 and continued right up to the commencement of this formal hearing. That was made clear during cross-examination when videos were shown and hearing transcripts were used to show their testimony was inaccurate and inconsistent. Regardless, they were not qualified at 10 and 7 to testify and establish as a matter of law that the marks that Tracy Green allegedly saw were not arguably child abuse, but were in fact child abuse. That element must be proved by some chargeable authority, making a determination that, quote, marks, close quote, whatever that may have meant, were the result of de facto child abuse. Again, Gary Davis Head was never charged with child abuse over the handprint incident. Judge Green has testified at length that, but for the red handprint, she never saw a single mark on the bodies of Gary Jr. or Russell that occurred as the result of physical discipline or corporal punishment. There is simply nothing in the record to support a legal conclusion that the marks that the boys say that Judge Green had to have seen were child abuse. Likewise, there's simply nothing in the record to support a legal conclusion that the red handprint that Judge Green did see was child abuse. There is no doctor's opinion, no expert testimony, no criminal charge, no CPS petition allegation in this record. Without that first foundational element, actual child abuse, being proved, counts 1 and 2, covering up evidence of child abuse, and false statements about knowledge of child abuse fail. As to the second foundational element, actual knowledge of child abuse, disciplinary counsel has likewise not met their burden. It is unfortunate that the boys lived in maladjusted and unstable family environments. Recall the testimony of Judge Green when she shared with us her disappointment and having to deal with situations created by her son due to poor choices that he made. In 2015, when they were only 7 and 5, their mother, Corey Bressler, lost custody of the boys and subsequently abandoned her sons for 3 years. During this time, they lived with their father, stepmother, and step siblings until June of 2018, when they were removed from their home by CPS due to reports of physical abuse. It was not until that time that the boys ever alleged that their grandmother, Judge Green, was aware of the alleged corporal punishment and the abuse that they received at the hands of their father. There are only 3 people who have given testimony on this record regarding the knowledge that Tracy Green had regarding alleged child abuse: Gary Jr., Russell, and Judge Green. Cross-examination of the boys was a difficult and emotional task. One thing that was demonstrated throughout the testimony was their respective inconsistencies and lack of credibility. Both boys admitted their lack of recollection of most of the details regarding what they alleged occurred. They did not testify to any details. No who, what, when, why, how, or where. Without those details, it is impossible to determine the critical foundational question of whether there was child abuse. The same shortcomings were evident when the boys did not testify to any details of how Judge Green allegedly had knowledge of child abuse. Again, no what, when, why, how, or where. Not even speculation or conjecture on their part is in the record. They could not provide details. Simply conclusory statements that Judge Green, quote, knew, close quote. Without those details, it is impossible to determine the second critical foundational question of whether there was knowledge of child abuse. Over the course of his many interviews and shown during his cross-examination, Russell testified to having marks on his face, and then no marks on his face, but then to having marks on his arms and legs. Even after the formal hearing commenced, during his June 10th, 2021 interview with disciplinary counsel, Russell described the makeup and how Judge Green applied it to his face. On June 28th, he testified that Judge Green did not put makeup on his face. Specifically, he said, quote, "No, not on my face. Well, I really can't remember if she did to my face, but I know for a fact that she did it to my brother's face," close quote. Yet he explained his earlier claims and testified for the first time in these proceedings that Judge Green had put makeup on his arms and legs. When questioned about this new claim, he said, quote, "I've told people that she put makeup on me before, but this was years ago, so I don't remember exactly where it was at," close quote. Again, no details, no who, what, when, why, how, or where. His testimony was also shown to be unreliable when he said in an earlier interview that the makeup that Judge Green allegedly applied to his face was with a brush. Then he said it was cold, as if it were a liquid, such as the liquid foundation that he saw Judge Green apply to the face of his big brother one time. Judge Green never put makeup on Russell's face. Judge Green never put makeup on Russell's body. It is clear that he is recalling the time that Judge Green did, as has been acknowledged, put makeup on the face of Gary Jr. Russell made that clear when, in response to the question of whether and how many times he had ever testified or given a statement that his grandma put makeup on his face, he testified, quote, "I don't think any times. I don't know, but I know she put it on my brother's face, my brother Gary's face," close quote. He spoke about observing wild sex parties with naked men running through their home while he and his other 4 siblings were present. None of his siblings corroborated this story. In fact, no one corroborated that story. He testified that his dad had killed one of the naked men. There's no corroboration of that. Russell was all over the place, but he was only 7 or 8 when he began to recount these events, after his mother had regained custody. And then, interestingly, he testified that Judge Green had knowledge of marks on his body and using makeup to cover up the marks. He was aware that Judge Green did apply makeup to the face of Gary Jr. once. He watched it, he saw it happen, and the next thing you know, he said it happened to him too. Not surprising that a little boy would equate or ascribe a situation such as that to himself. Russell was not credible. Gary was not credible either. Gary Jr. told the Kids Talk interviewer on June 28, 2018, that his father had, on a single occasion, struck him 500 times, taking breaks between every 100. He was certain about the number of strikes because he, quote, counted them, close quote. Gary Jr., by his own admission, deceived disciplinary counsel in this very case. He admitted that he was not telling the truth to disciplinary counsel Ms. Weingarten during his interviews about having contact with his father. Recall the testimony about the Uncle John letter, the one he said that Judge Green told him to write and assisted him in doing so. Ultimately, disciplinary counsel realized something did not add up and talked with him about having a Detroit Police Department computer technician gain access to his computer. Lo and behold, he then came to Ms. Weingarten and said he needed to tell her something, and then admitted that he had not been telling her the truth about the entire event. As opposed to allowing him to explain the details of his deception, disciplinary counsel summarized it for him and then simply asked on the video if the summary was true. And he said it was. If he worked so hard to deceive and perpetuate and maintain those untruths with disciplinary counsel in this very case, why should his veracity and credibility be accepted as to anything else about which he has testified? Gary Jr.'s untruths about Judge Green's involvement with the Uncle John letter shows that he will choose not to tell the truth when it suits him. Gary Jr. testified that he thought he told Judge Green that he and Russell were getting beatings and she knew of the abuse. He thought. But again, no details. No who, what, when, why, how, or where. Gary Jr. knew he was not being truthful during his testimony. When examples of his inconsistent statements were shown to him, both by transcript and video, he came apart in an emotional and an alarming display. Everybody in this case recalls the details of that quite well. It was shocking and unsettling. It was clear that Gary Jr. did not want to say anything to hurt Judge Green on the stand, but he had to stick with the script created by his mother. Even though his mother had abandoned him again, Gary Jr. did not want to draw his mother's ire. He wants to return to her home, and he believed that his testimony against Judge Green would please his mother. Gary Jr., by definition, as someone who has admittedly not been truthful in this very case, and that fact having been confirmed by video acknowledgement and on the record, lacks credibility, and his testimony should not be believed or carry weight. It is critical to note that Gary Jr. testified that everyone at school saw the marks and the handprint on his face. He even testified that the teachers did too. Specifically, when he was describing the handprint as, quote, pinkish, close quote, he testified, quote, everybody in my class knew that I got slapped, close quote. So we confirmed that the handprint left by the slap and the makeup applied by Judge Green happened sometime around the 2017-2018 time period of the school year. But we have heard from both his third grade and fourth grade teachers, both of them highly educated, certified, and trained as mandatory reporters, and one of them who is now an assistant principal. They both testified that they specifically remembered Gary Jr. as a student. They both testified under oath that they never observed a handprint on his face or any sort of a mark on his body at any time. You also heard from Simone Head, Judge Green's 19-year-old daughter and the aunt of Gary Jr. and Russell. She testified to spending extensive and regular amounts of times with the boys and never seeing marks on their bodies at any time. Likewise, Andre Green, Judge Green's husband and the papa of the boys, testified that he never saw marks on the bodies of the boys. So we expanded the search out one more concentric ring. Church ministry leaders, Marcus Holmes and Tamika Brown Edwards, saw the children regularly, but never saw marks on their bodies or ever suspected any abuse. In fact, Mr. Holmes testified that he would see the boys visit after church with their maternal relatives, Lonnie Peak and great-grandmother Patricia Peak Russell. But these relatives never testified that they saw or heard any evidence of abuse. We heard Gary Jr. say over and over again that he did not recall specifics about which he was testifying. There were times when he answered, quote, "I don't know," close quote, to multiple long series of questions. We heard him say over and over that he did not want to be at the formal hearing and did not want to testify. Recall, please, that disciplinary counsel picked him up, brought him to their offices at the Judicial Tenure Commission, and gave him a room from which to testify. Disciplinary counsel even bought him lunch. Recall that he admitted disciplinary counsel told him that he was subpoenaed and might go to, quote, juvie, close quote, if he refused to testify. Judge, Gary Jr. is a 13-year-old boy. Disciplinary counsel attempted to support their allegation that Judge Green had knowledge of child abuse by calling Detroit Police Department Officer Adams. Officer Adams was allowed to testify concerning purported excited utterances made by the boys on June 24, 2018, the day that they were removed from their father's care. She said that she spoke to Gary Jr. and Russell together, and Gary Jr. told her that they did not want to go with Judge Green when they were being removed from their father's house because she knew about the abuse. Notably, neither of the boys testified that she observed any corporal punishment occurring at the hand of their father. Again, no specifics of what they were allegedly talking about, and certainly no legal confirmation that they were talking about what amounted to child abuse. Recall that the boys admitted that by this time, June 2018, their mother, Corey Bressler, had attempted to re-enter their lives and had been emailing them, despite a no contact order. The emails clearly disclosed the plan that Corey Bressler had put into place to regain custody of the boys that she had abandoned 3 years prior. Multiple emails between Corey Bressler and the boys were entered into evidence. The first was a December 26, 2017 email from Ms. Bressler's email handle, quote, Corey's cards, close quote, that was sent to Gary Jr. The subject was, quote, mommy, close quote, and it said, quote, happy birthday, Gary. Tell Russie I love him and I love you. We will be together very soon, close quote. The orchestration of the plan. The boys were removed from their father's home by CPS on June 24th of that year. We saw a June 22nd and June 23rd email thread between Corey Bressler and Russell. In it, Russell says, quote, I'm sorry, with 7 exclamation points, close quote. Corey Bressler responds, quote, you don't have to be sorry. If you want, you live with your dad, that is fine. I did everything I could. CPS was going to bring you to me today. I told Gary that. Now they don't believe you're in any danger, close quote. Then she went on to say, quote, I can't call CPS anymore for you two. They are not going to believe me anymore, close quote. Russell then responds, quote, me and Gary will tell them everything. There you will be there to guide us, close quote. Disciplinary counsel wanted to keep parts of this thread from coming into this case as evidence. This is evidence of the plan that Corey Bressler was undertaking with the boys. She was playing her cards, Corey's cards, and the plan was to be effectuated in 2018. Corey Bressler told Russell to give an email address to Gary Jr. and told him that the password for the account was, quote, Mommy 2018, close quote. Corey Bressler goes on to manipulate the boys and says, quote, it's too late now. You should have spoken up when you had the chance. There is nothing I can do now. I will still bring you for visits, but it will take some time, close quote. This is why both boys denied and disassociated themselves with this email thread. Russell claimed Gary wrote it, even though the conversation was clearly between Corey Bressler and Russell, and she directed him to give Gary Jr. a message. In an email exchange the following day, June 24th, 2018, the day that the boys were removed, Russell tells his mother that he was told that it was not likely they were going with her, but it was possible. Corey Bressler responded that she wanted them to go to her mother-in-law's, not with her. And 1 minute later in the thread tells him, quote, if you go with people your daddy knows, he will be able to get to you, close quote. All of this is consistent with her plan to try to regain custody of her boys. And she certainly knew that Judge Green and her husband would be interested in taking custody of the boys when removed from her son. After 3 years of abandonment, as has been confirmed on the record, Corey Bressler did not even attempt to establish a supervised parenting plan with GrowthWorks in order to see her boys until June 5th, 2018, 19 days before they were removed from their father's home. Bressler had to know that Judge Green would be asking to take the boys if they were removed from their father. It was not until Ms. Bressler had reestablished contact with the boys, only part of which is disclosed in the emails, that only one of the boys, Gary Jr., mentioned to police officer Adams that he did not want to go with Judge Green and her husband. But Officer Adams had prepared a 6-page report, 3.5 pages of which contained her single-spaced, exhaustive narrative of what occurred that day during her investigation. Judge Green is not mentioned anywhere in that report, despite all of the other exhaustive content. Nowhere is there a reference to the boys not wanting to go with Judge Green. Officer Adams testified that she prepared the report within hours of the run and included what she considered important. Then, more than 3 years later, she claimed to have a recollection of a momentary discussion with the boys about where they wanted to go, but not a single reference about that, quote, important, close quote, point in her exhaustive report. She testified, quote, not saying it wasn't important enough, I just didn't put it in there, close quote. This is not something an experienced Detroit Police Department officer would fail to do, especially if she was so emotionally affected as she claimed to have been. Corey Bressler was under subpoena to appear at this very formal hearing. Disciplinary counsel was advised that sometime before she was scheduled to appear, Bressler moved away. Your Honor entered an order compelling her to appear and testify. She failed to appear and answer questions regarding her involvement and disdain for Judge Green. She knew that CPS would not support her having custody of her 2 sons over Judge Green and Mr. Green, their grandparents, because she had previously lost custody and did abandon them for 3 years. But while we're not hearing from her live, despite her violation of Your Honor's order, we do have her YouTube channel videos in which Ms. Bressler attacked Judge Green with wild-eyed rants such as, quote, Tracy Green is a very demonic human being. She is extremely manipulative, extremely mean-spirited in her heart. Her soul is rotten, close quote. She claimed that Judge Green, quote, took my children from me and gave them to her son, close quote. She spoke directly to Judge Green in her videos, at one point saying, quote, you are not mentally stable. You are not emotionally stable, and you are not at all there. There's something missing pieces to your brain puzzle, close quote. Corey Bressler coached her sons, who were desperate to live with her father after her 3-year desertion, to say and do whatever possible to avoid being placed with Judge Green and her husband. And then there is the testimony of Judge Green, who testified consistently that she was unaware of child abuse, something that, with her career-long experience in the occupational and professional realms of child welfare, knew and understood well what it meant. Not to mention that it related to her own grandchildren that the record clearly shows she loves, cherishes, and has tried to nurture both emotionally and spiritually. Her husband and daughter and 2 church ministry leaders testified that Judge Green objectively loves her grandsons and would have never allowed them to be victims of abuse had she been aware. Judge Green was unequivocal that she never saw evidence of child abuse. No marks, no evidence. She did admit to seeing a red handprint, and interestingly enough, she was the one who told CPS about the handprint in the first place. And she specifically acknowledged that once the oldest of her 2 grandsons, Gary Jr., told her that he had been slapped in the face by his father. She testified she saw what looked like a handprint on his cheek at that time, and the boys confirmed that Gary Jr. had been slapped by their father. Please consider for a moment, if she had something to hide in terms of evidence of child abuse, why would Judge Green have volunteered to CPS that she had observed a red handprint left by a slap at the hand of her son? Regardless of whether she told CPS about the makeup she applied on the handprint, Judge Green certainly knew that CPS would investigate the handprint incident by asking Gary Jr. and Russell about it. She did not want CPS to disqualify her for placement consideration if they learned about it from someone else. Interestingly, neither Gary Jr. nor Russell ever raised the allegation that Judge Green put makeup on Gary Jr.'s handprint to anyone. The only logical explanation for their failure to do so is because they both knew why Judge Green applied the makeup. In other words, to make Gary Jr. feel better after his embarrassment and Russell's teasing. Gary Jr. even testified that he did not think her doing so was, quote, that big of a deal, close quote. After being made aware of the slapping incident, seeing what looked like a handprint on the face of Gary Jr., and considering it totally inappropriate and unacceptable, she immediately contacted her son and scolded him. She did exactly what any loving grandmother would have done. She admonished her son and comforted her grandson. She was satisfied that the issue had been addressed as improper and would never be repeated. She was never made aware of any subsequent corporal punishment. She was never made aware of any abuse. There is no evidence in the record that she was made aware of any subsequent corporal punishment. She did not consider that single incident of a slap in the face something that should be reported to law enforcement or CPS as child abuse. Nancy Deal's expert testimony supports Judge Green's view, and disciplinary counsel has no testimony, fact, or expert with which to claim otherwise. Disciplinary counsel has not established the necessary element of a finding of child abuse. Disciplinary counsel must prove in count 1, covering up evidence of child abuse, that Judge Green actually covered up evidence of child abuse. Judge Green also explained in great detail that on a single occasion, after learning that her grandson was being teased by his brother after being slapped and was emotionally upset, she offered the 9 or 10-year-old boy a Band-Aid-like relief by applying liquid foundation to the handprint on Gary's cheek. This instance is the one and only occasion in which Judge Green did so, and it was with Gary Jr. She never put makeup on Russell on any occasion for any reason. The boys said generally that she applied makeup to Marks on more than one occasion. Notably, this was the only time that there was specific recollection of that occurring and an admission that it did occur and corroboration that it did occur. This begs the question then as to why Judge Green would have admitted this had it not been true. There's no dispute that she was the one who told CPS about the handprint. There is no dispute that in this proceeding, at a minimum, she admitted that she did so. She testified that she did not think the handprint was child abuse and did not think that she was covering up evidence of child abuse. If this were revisionist history and not true on her part, she could have simply denied that it ever occurred and instead challenged the veracity of the boys when they claimed that it had happened. Why would she admit that she applied makeup once, but then deny that she did it more than once? It doesn't make sense. Because she only did so one time and there is no credible evidence in the record that it occurred more than once. Remarkably, as to this single occasion, and unlike the vague statements made by the boys, Judge Green recounted each of the details of the who, what, when, why, how, and where. MCR 9.233 mandates that disciplinary counsel at all times shall have the burden of proving the allegations by a preponderance of the evidence. Disciplinary counsel has not met their burden in this respect as well. Respectfully, with no evidence in the record confirming anything that Judge Green allegedly observed in terms of vaguely described, quote, marks, close quote, or even arguably observed in terms of a red handprint left by a slap to the cheek, legally amounted to child abuse and actual evidence of child abuse, there is nothing that Your Honor, as the master, must decide under a preponderance of evidence standard of proof. Without that foundational element of child abuse and actual evidence of child abuse being proved, there is no legal basis, no foundational element upon which to move to the second question of whether there was a covering up of evidence of child abuse. As a result, count one, covering up evidence of child abuse, necessarily fails. In count two, false statements about knowledge of child abuse, in addition to having to prove the elements as I've described of child abuse and knowledge of evidence of child abuse, disciplinary counsel must also prove that Judge Green made a false statement about her knowledge of child abuse. In an effort to prove that false statement, disciplinary counsel took Judge Green's admission to having applied makeup to a handprint on the face of Gary Jr. and attempted to demonstrate that she was inconsistent in prior statements. For the first of these false statements, disciplinary counsel points to Judge Green's March 2019 juvenile court trial testimony. This is the first occasion in which disciplinary counsel alleges that Judge Green made a false statement when she was an actual judge. She took the bench in January of 2019. In her testimony at that hearing, Judge Green admitted that she had seen a handprint on the face of Gary Jr. and that the handprint was from her son. Then she was specifically asked if she had ever used makeup to cover up bruises on Gary Jr.'s face. She answered again that she had never seen any bruises, and she acknowledged that she never used makeup to cover up bruises on Gary Jr.'s face. In May 2019, Corey Bressler presented her boys to Mr. Elric, a former investigative reporter with Fox 2 News, for an interview. They were 11 and 9 at that time. During that interview, the boys stated that Judge Green knew about the physical abuse they suffered at the hand of their father, used makeup to cover up bruises, and did nothing to stop it. These were contrived statements they made subject to coaching at the hand of their mother, who blamed Judge Green for loss of custody of the boys in 2015. Judge Green agreed to be interviewed by Elric at Fox 2. During that interview, she stated, quote, "I didn't put makeup on any bruises to conceal any abuse. That is utterly preposterous. It just didn't happen," close quote. Disciplinary counsel dramatically played a 6-second excerpt from Judge Green's interview with Elric that included that very soundbite. Neither the March 2019 testimony nor the May 2019 statement was a false statement. Judge Green did not put makeup on a bruise. She put makeup once on a red handprint that Gary Jr. said was pink and went away. During her testimony in this case, Judge Green explained her understanding of the difference between a red handprint on a cheek and a bruise. She explained that she carefully answered those questions. While disciplinary counsel argues now that she was intentionally holding back information, it is clear that she did not make a misstatement or a false statement. Disciplinary counsel claims that she should have admitted that she applied makeup to the face of Gary Jr. Again, as was the case with the juvenile court trial, she was questioned about bruises, not a red handprint. That even Nancy Deal testified she had never even heard considered to be child abuse. There was nothing to admit in response to those questions. Notably, Judge Green denied ever seeing bruises on the bodies of the boys, but acknowledged before this matter ever commenced that she had seen a handprint. Judge Green was never asked by anyone if she ever applied makeup to a handprint. Additionally, Mr. Elric's question asked about concealing abuse, which Judge Green ardently denied. Notwithstanding, she did and has, in fact, admitted that she applied makeup to Gary Jr.'s cheek in this matter. She's never denied that she did so on that one occasion and has explained the exact details, and particularly during her testimony in this case, explained why she felt it was appropriate to do so. Disciplinary counsel cannot demonstrate a false statement about her knowledge of child abuse. Please consider for a moment why, if she had something to hide in terms of knowledge, Judge Green would have volunteered to CPS and later acknowledged on the record under oath that she had observed a red handprint left by a slap at the hand of her son. It would have been foolhardy to have made those acknowledgments had she believed or even suspected the existence of child abuse and had arguable knowledge of that child abuse, and then took steps to cover it up. Rather, Judge Green could have eliminated the question entirely by simply not seeking placement of her grandchildren. Gary Jr.'s account of the makeup incident is not credible. Note how Gary Jr.'s account of the handprint and makeup incident materially changed over time. On March 12th of 2018 in the juvenile court proceedings, 10-year-old Gary Jr. then testified that Judge Green put makeup on his face before leaving her home to return home to conceal evidence of abuse from people at school. Undoubtedly realizing that this testimony did not make sense when confronted with pointed questions about why the makeup applied the night before for school did not wear or rub off during his sleep or shower, Gary Jr.'s response was to say that he had not said it had not worn off. He made no mention of Judge Green providing Katie, his stepmother, a quote, touch-up palette, close quote, for use before school, to which he certainly would have testified in response to these specific questions about the application of the makeup had his account about Katie's involvement been true. After Judge Green became a judge during the entire period, Gary Jr. was under the exclusive control of his mother. Gary's account is not reliable. Disciplinary counsel did not call Katie to corroborate the account. Without those foundational elements of child abuse, actual evidence of child abuse, and Judge Green having actual knowledge of child abuse being proved, there's no legal basis upon which to move to the final question of whether false statements were made about knowledge of child abuse. As a result, count 2, false statements about knowledge of child abuse, necessarily fails. The final count is literally brand new, count 3, knowingly false statements to the commission. Here, disciplinary counsel alleged that Judge Green made a false statement in her answer to complaint to the effect that she advised CPS of both the handprint on the face of Gary Jr. and that she had applied makeup to that handprint. Disciplinary counsel spent days on this issue and called all of the CPS witnesses twice, once on the record and the second time on a separate record. They introduced multiple versions of two different CPS reports that they argued showed that because it did not say that Judge Green told CPS about the makeup during her interview in 2018, that she was thus making a false statement in her answer to the complaint. Critical here is the fact that disciplinary counsel did call Judge Green as an adverse witness on September 17th and asked her about what she said in her answer. She explained candidly that she was simply uncertain then as to whether she told CPS about both points, the handprint and the makeup. Her explanation makes sense. The answer was filed in December of 2020. She confirmed the details of that answer under the penalty of perjury by verifying that the information was true and accurate to the best of her knowledge and information, and as to those matters based upon belief, she also believed them to be true. Much has occurred since that time, such as exhaustive discovery and multiple days of formal hearing. She has, since December of 2020, as part of her preparation for this case, reviewed dozens of hours of video interviews, reviewed hundreds, if not thousands, of pages of material, and has had innumerable hours of discussion with counsel. She acknowledged that she could not be certain if she mentioned the makeup, but may have done so. Who knows if she did? The CPS reports are most certainly not a formal record of whether she did or did not. As the master was advised during oral argument during an earlier motion, Judge Green agreed to stipulate to the CPS reports not containing a reference to makeup on a handprint. Disciplinary counsel refused the stipulation, instead wanted to call the CPS workers to confirm that fact, and they did so by way of separate record. Again, Judge Green does not now recall with certainty whether she told Leslie Apple about the makeup. But if she did, Ms. Apple was not going to acknowledge that she did when it was not noted in her reports. Recall the testimony of Ms. Apple about her reports being doctored and changed and things being mysteriously removed from them without her knowledge or approval. Ms. Apple's testimony should not carry weight in any respect. Judge Green testified that she felt Ms. Apple had a bias towards her and in favor of Corey Bressler because Judge Green had accused her of not following the rules and properly investigating Bressler as a custodial parent. In fact, Judge Green's call to Ms. Apple and complaint about the mental health status and violence concerns about Bressler was glaringly absent from Ms. Apple's report. Apple was ultimately removed from the CPS investigation and replaced by a new worker after Judge Green took the bias issue to her supervisors. It is important to note that she has never denied applying makeup on this single occasion to the cheek of Gary Jr. How was this making a false statement to the commission? The statement has not been shown to be false. Judge Green cannot say whether it is or is not accurate because she is uncertain. But regardless, she has acknowledged that it may not be accurate only as to the makeup question, not whether she told CPS about the slap and the handprint. But disciplinary counsel has a fatal shortcoming in the evidence here. They must prove that Judge Green had intent to deceive. Intent that the charge was knowingly made. They have not shown that to be true, and how could they? Judge Green explained her statement. Disciplinary counsel cannot prove that the explanation is not true. You've heard from family and church members that Judge Green loves her 5 children and 7 grandchildren. She maintains an outstanding reputation. She has a reputation of honesty and is above reproach. She's known as very compassionate. And Mr. Green specifically testified that using makeup to help make Gary Jr. feel better is just the sort of thing she would do. She has explained how and why all of her grandchildren are precious to her. Those around her have confirmed that fact. She's been a state bar member for almost 25 years, and of all of those years before taking the bench in a practice that related to family law and the welfare of children. The claims against Judge Green are incongruous with her reputation and service in the child welfare space. It does not make sense that Judge Green would have turned a blind eye and not have protected the best interests of her grandsons had she been aware of child abuse, regardless if it was at the hand of her own son. So too is it unreasoned to hold that Judge Green would have jeopardized her reputation and career by being aware of actual child abuse, not protecting the best interests of her grandsons, and then covering it up by hiding the truth. Your Honor has heard all of the proofs. On behalf of Judge Green, I respectfully request that you find that the claims against Judge Green lack both factual and legal bases, and disciplinary counsel have failed to establish by a preponderance of the evidence each of the required elements of proof. Thank you, Your Honor.
Thank you, Mr. Ashcraft. At this time, we'll take another short break, about 5 minutes, and then we'll come back for your brief rebuttals. You may certainly mute your audio and close off your video at this time.
Thank you, Judge.
All right, we are back and I am ready for you to continue. Disciplinary counsel, please.
Your Honor, I'm going to zip through my rebuttal in no particular order. Officer Adams testified, and you know that Mr. Ashcraft now argues that how could she possibly remember things that she didn't write in her report? Well, she testified she had the independent recollection of the facts of this case, even 3 years later, because it was the first time in her career that she had to remove children from a home. She remembered the boys and she thought they were really sweet, and this was a big deal for her. There's no reason to doubt her recollection. Miss Apple was present when Max made that statement to Officer Adams about why he didn't want to go with his grandmother, and Miss Apple corroborates Officer Adams' testimony. So there's no argument that she made it up, even though she didn't write it in her report. Then counsel talks about Corey Bressler and her coaching. If Miss Bressler was that invested in getting Judge Green, she would have gotten herself here to testify against Judge Green instead of absenting herself from the proceedings. She would have seen it through to the end. And she didn't do that because she doesn't care about what happened to Judge Green, because that's not her thing in life. She's not out to get her. Now, as to Judge Green's statements to Miss Apple, Mr. Ashcraft asks, why would she even admit that she saw a handprint? Well, it would have been tough for her to admit that she knew nothing under the circumstances. She had to admit she knew some of this. And early on, she was cooperative with Miss Apple. She was partially truthful with Miss Apple. She testified that her son was she said to Miss Apple, her son was a strong disciplinarian. She saw the handprint. She didn't know it was this bad. But she also knew from being an insider in the system that the consequences to her son would be minimal, because she worked in the system and she knew that what the system would do under these circumstances was put in services like parenting classes. So she had nothing to lose by sharing that information with Miss Apple, and it didn't, in her mind, affect her son very negatively. Then counsel argues a red handprint on the face of a child is not child abuse. Well, that's what he wants to frame this case as. It's only about one red handprint, but that's not what this case is about. This case is about repeated abuse of the boys in the forms of slaps, spankings, beatings, and the use of a belt. Judge Green wanted to call the slap mark a pink, fading, three-fingered mark. That's what she testified to minimize the seriousness of it. The fact that it lasted and that she felt compelled to cover it with makeup to avoid others from seeing it shows that it was serious. So whether she calls it a handprint or a bruise is really irrelevant. She knew it was an injury inflicted by her son upon her grandson that she called inappropriate, unacceptable, and not reasonable parental discipline. She wants to frame the injury as insignificant to help her explain away her prior lies and explain why she didn't report it to the authorities or protect the children. Then counsel argues that the children gave no specificity of details. Well, when something happens repeatedly over a period of time, no child is going to remember dates or times. She had knowledge of child abuse. They told her multiple times. They showed her multiple times. Yeah, they weren't able to provide a date of when they showed her or a date of when they told her, but they told us multiple times she was aware of it. Then counsel takes issue with Russell's credibility and talks about the inconsistencies about the makeup story. Well, Russell was very young and he doesn't remember well whether or not Judge Green put makeup on him or on what parts of his body she did put the makeup on. And counsel's arguing that makes him incredible. In addition, he talks about how Russell says some very bizarre things about his father having naked parties and having men over. Well, I don't think that what Russell testified to is so bizarre. This was a very disturbed household. The naked man story could be true. His father could be bisexual and he could be into having orgies. So what Russell said is not inherently unbelievable, and there's been no evidence to contradict his statements. Now, Russell now says he doesn't remember ever saying there was a murder. Now, if he'd stuck with that story that there was a murder, he would be lying or he'd be incompetent to testify, but he didn't stick with that story. When Russell was interviewed about Judge Green's conduct, he was older, and the things he said were not fantastic, and they were consistent with what Max said when he testified. Then counsel says, well, Max is particularly unbelievable because he's an admitted liar. What we put Max through collectively was really, really tough on him. We all saw the emotional toll it took. He could have easily recanted the allegations just to put an end to his having to testify, but he didn't do so. He told us, I don't care if I'm believed or not. This case doesn't matter to me. And in spite of not wanting to testify, he said he told the truth. Counsel argues, well, Max wasn't credible early on because he said he was struck 500 times by his dad. Well, maybe he was struck 500 times, but maybe he wasn't. But maybe it just seemed like he was struck 500 times. Any child who's being beaten with a belt probably thinks he's being hit 500 times. Then counsel says no one saw marks on their bodies. Well, their father wouldn't let them out in public when they're injured. He pulled them out of school to limit their contact with the outside world. Before they were pulled out of school, they wore uniforms that included long pants, and they didn't change clothes before gym class. They had little contact with non-family members after their removal from school. The boys don't know when they stopped going to church, and the church personnel didn't keep attendance and don't know when the boys stopped going to choir or fellowship or church services. But even if they did go to those events at church, their bodies were covered with clothing. Nobody asked them to disrobe. Then counsel talks about the emails. The emails, when read in their entirety, show a concerned mother trying to get her children out of an abusive situation. Max and Russell both said that one email that they could not authenticate was the one where someone wrote, "You will be there to gild us." They both say, we didn't write that. And Max said some of the emails didn't seem legitimate. Your Honor should remember that we got these emails from Mr. Ashcraft's office. Mr. Ashcraft said there were other communications with Corey Bressler, but there was one or two short phone calls. And I don't think a lot of coaching could have occurred even if they wanted it to during those one or two very short phone calls. The first thing Mr. Ashcraft argued is that judges who are parents or grandparents will not be allowed to be grandparents or parents in full. This is what judges are going to learn from this situation and this hearing. Judges will learn not to conceal physical abuse on their children or grandchildren. Judges will learn not to lie under oath when asked questions about whether they knew about abuse of their children or grandchildren. And judges will learn not to lie and say they told CPS something they did not tell CPS about. Thank you.
Thank you. Mr. Ashcraft, ready to hear from you.
Thank you, Your Honor. Disciplinary counsel said that this case is not about, quote, the abuse, close quote. It's only about, quote, Judge Green's knowledge, close quote. If we carefully look at the three charges as contained in the amended complaint, as I have highlighted, there is a systemic problem in the fact that the first foundational element to even get to the charges is absolutely clear, and that is the existence of child abuse. There is no confirmed child abuse in this record. They had opportunity over the course of 11 days, months of testimony and months of preparation to find corroboration or substantiation for that, but there is none. Disciplinary counsel says words like Judge Green was, quote, aware, close quote, of abuse of Katie. Judge Green was, quote, aware, close quote, of her son being a stern disciplinarian. Disciplinary counsel used the word aware throughout her presentation. But once again, The who, what, why, when, where, and how are missing. The foundational elements for this being evidence carrying weight and credibility is not there. It's lacking. There simply are no proofs. Disciplinary counsel makes a vague reference to, quote, evidence, close quote. But again, not the specifics of that, just an explanation of what they think it is and what they think it shows. But as I pointed out, there are no foundational premises supporting any of these things. There's a reference to based upon the testimony of the young boys. Well, they were young boys, but not just based upon the fact that they were young boys, but their credibility was called into contest specifically through examples of inconsistent statements in transcript and on video interviews. With regard to Ms. Apple, Judge Green supposedly knew about abuse, but not that it was, quote, that bad. This was a single line in a CPS report written by Leslie Apple, not cleared with Judge Green. Judge Green was never asked of whether her statement was being taken out of context or what it meant. There was no follow-up to ask about that. It was a single line in a CPS report that was written by someone that later testified that she had been accused of bias, had been removed from the CPS investigation by her superiors, and Judge Green was the one that raised that issue. And she also made reference to her reports being altered. Disciplinary counsel says that this is, quote, implicit, close quote, acknowledgement of Judge Green's knowledge of abuse. It's not implicit knowledge in any respect. Disciplinary counsel has to prove intent and then actual knowledge. None of those things exist here. Requiring Judge Green to, in essence, prove a negative based upon someone else's written sentence in a CPS report is completely inappropriate. And importantly, Your Honor has already ruled that those CPS reports are only into evidence for purposes of establishing context to show whether or not Judge Green had made a statement about putting makeup on an injury. There were multiple interviews of the boys, multiple interviews, certainly in excess of a dozen. They did not comply, all of them at least, did not comply with the forensic protocol. Disciplinary counsel has, in essence, spun that it was Tracy Green who has testified in a self-serving way, but the disciplinary counsel, because she was trained in the forensic protocol, actually benefited Tracy Green by getting a revelation that Gary Jr. was not telling the truth. Was that her attempt at rehabilitating Gary Jr.? Disciplinary counsel gave the boys a pass because they were of young age and the passage of time. They shouldn't receive a pass. No one should receive a pass in that point. Disciplinary counsel says that the boys' testimony was, quote, fairly consistent, close quote. Fairly consistent does not establish proofs and does not establish individual elements. The same boys who confirmed these elements yet indicated that their deceit, specifically Gary Jr., that he was deceitful, and he acknowledged that in his testimony. And we've also demonstrated the inconsistent testimony of Russell. These are the boys that are now establishing elements? No, they are not. Gary Jr.'s lie was specifically about Tracy Green. That's what disciplinary counsel has argued. Contrary to what disciplinary counsel now tries to say in trying to rehabilitate Gary Jr., the fact is that he is not credible. It was not early on that he told this lie. It was during the course of these very proceedings, interestingly, while being interviewed by disciplinary counsel. Disciplinary counsel makes reference to a leap that Russell had no reason to lie. Well, that's not true. He was back with his mother and then for the first time ever claimed that Judge Green was, quote, aware, close quote, of child abuse and did nothing. The timing of that is notable and remarkable and cannot possibly be happenstance or serendipity. Now, with regard to Ms. Weingarten's testifying on her own behalf regarding the protocol, please review the testimony of Nancy Deal, and most importantly, the cross-examination or attempted cross-examination of Ms. Deal by disciplinary counsel. Note how disciplinary counsel did not get the answers to her questions that she had expected, and then she moved on to other areas. The things that disciplinary counsel testified to self-servingly, as she's accused Judge Green of doing, while she was on the stand during rebuttal, are inconsistent with the things that Nancy Deal testified to, who disciplinary counsel stipulated was an expert on the forensic protocol and an expert in child protection law. It begs the question, Judge, why did disciplinary counsel not have an expert in this case? I'd like to talk for a moment about the excited utterance Gary Jr. gave to the police officer, Ms. Adams. It was about not wanting to go with Judge Green and her husband. But look at the emails from June of 2018, where Corey Bressler says that the boys cannot go with first can't go with her. She wanted them to go with her in-laws. And then second, the boys couldn't go with anyone in their father's family because he could still get back to them. This is what generated the excited utterance, if the excited utterance ever occurred. It's also critical to note that disciplinary counsel morphs and then melds their words from one to another. They use words such as bruises, and that morphs into marks, and that morphs into injuries, and that morphs into abuse. They must do this because there's only one uncontroverted and unequivocal admission of something happening in this case with regard to a mark. That was a red handprint. And on that red handprint that was described as pinkish, Judge Green applied liquid foundation once to console her grandson. Judge Green, Gary Jr., and Russell all confirmed the details of that incident. Disciplinary counsel says that the truth remains the same, but lies change. If that is true, Judge, then disciplinary counsel, by their own statement, has conceded that Gary Jr. is not credible and Russell is not credible. Again, as detailed, there are only three people that know exactly what happened here: Judge Green, Gary Jr., and Russell. Now, there's a reference to Gary Jr. testifying about his contact in May of 2021 with Judge Green. I'll point out, Judge, that there was never any discussion about this case. There was never any instigation or contact made by Judge Green. It was acceptance of contact by Gary. And then after this was brought to the attention of disciplinary counsel, we agreed there would be no further contact, even if he tried to reach out to her again. But there's some statement here about it was Judge Green that told Gary about the makeup and the use of the makeup. And I believe disciplinary counsel said in her attempt to get a, quote, buy-in, close quote, from Gary. But there is no proofs in this record, none at all, that ever occurred. So even if we question, well, how is it then that Gary would know about the use of makeup? Well, the answer to the complaint specifically made reference to it throughout. The answer to the complaint is online. Disciplinary counsel speaks out of both sides of their mouth about this self-serving testimony by Judge Green. Gary Jr. had not been cross-examined at the time he lied. That's a very important point. Disciplinary counsel makes it appear as if it was the exhaustive cross-examination that he underwent and what he had to deal with bilaterally in this case when he was examined and cross-examined. But the lie occurred before that, during an interview with disciplinary counsel. Disciplinary counsel once again holds to this phrase of repeated quote, abuse, close quote, but there are no proofs in the record and nothing establishing child abuse. And that's because disciplinary counsel cannot do that. It is a fundamental, required, foundational element on these charges. Finally, there's reference to Ms. Bressler not being here because she could have gotten herself here if it were an important point. Well, Judge, we did everything we could to possibly get her here. I wasn't allowed to have any contact with her. She refused to contact or have contact with me, but disciplinary counsel had contact with her. Disciplinary counsel actually got permission from her to accept the service of my subpoena. There's a very good reason why Corey Bressler did not appear. It was because she was going to be cross-examined about the statements in her videos, about the emails, about her orchestrated attempt to get the boys removed from the custody of their father, and did so by pointing a finger at Judge Green. Judge, I would respectfully ask that you consider the individual foundational elements required to be proved by disciplinary counsel that pursuant to this court rule that governs this proceeding specifically says they must prove every element and they maintain at all times that required burden of proof to meet it and find that there is no factual or legal basis supporting these charges against Judge Green. Thank you, Judge.
Thank you. Thank you, counsel. At this time, we will stop the live stream in just a moment, and we will continue to discuss some other matters that are not part of the hearing. Is there anything further from either disciplinary counsel or from Mr. Ashcraft?
No.
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 All right, thank you very much. It'll take me just a moment to stop this.